I'll start with my introduction team. My name is Introduction. So what is going to be the agenda of today's session? So in today's session, we are going to cover introduction to DPO course. What are the objectives, the course coverage, delivery format, how is the certification different from other versions, who should take this course and why with InfosecTrain basically, and what are the course outcome. A quick background about InfosecTrain. As an institute, we are established from 2016, one of the leading institute from when it comes to information security and data privacy training. And this is the numbers and some of our trusted clients and some of the reasons why should you opt for InfosecTrain. Okay. Now, just to start with the course introduction, right? So, the data protection officer hands-on training is based on two important regulations. One is your DPDPA, Digital Personal Data Protection Act, and the second is GDPR. Why these two courses alone, and why we have to cover both the courses? In fact, that could be one of the curious questions, right? So, one, we are looking predominantly from the Indian market, which there are a lot of people, aspiring people who want to pick up DPA, data protection officer role, and Indian market is gonna actually have a lot of requirement from DPO compared to the European and US counterpart, because they have been dealing with data privacy requirements for the last 10-15 years, right? Whereas for the Indian market perspective, it's pretty much a new domain because the law itself came only last year, and we are expecting the rules to come out maybe after June, July, once the new government is formed. So you will see once the rules comes out, there will be a lot of openings towards the data privacy manager, data protection officer. So that is one important reason we are aligning our content towards DPDPA. But the larger subset is your GDPR, because GDPR, if you have been listening to me in the past, I've always kept a stand that GDPR is a gold standard when it comes to data privacy laws. The reason is it's one of the most comprehensive law, and the coverage as well as the depth of the law is going to give you a lot of knowledge to cater to most of the data privacy laws in the world, right? So having said that, we cover both DPDPA and GDPR so that you are ready to actually tackle any other data privacy laws in the world. So that's the reason we are covering both DPDP and GDPR. And so the people whoever is attending this course definitely are going to have the essential knowledge and skills to run a data privacy program on a day-to-day basis. So that's the most important element of this particular course. So the course objective is obviously about GDPR and DPDP Act, and get a comprehensive hands-on knowledge and implementing data privacy program, and how a DPO is going to maintain and run this program, and what are the nuances. So you will get a lot of insights about each and every element of a data privacy program. With all my experience, I've brought some very important insights, which is only gained after implementing data privacy programs across different organizations, and developing capabilities for handling data subject rights, data breach, and there are multiple elements including how to integrate the privacy by design. All these things are going to be some of the key objectives of this course. Okay, now coming to one important element, which is the course coverage, right? So I can definitely challenge on this particular part. You can check any of the other course coverage which is existing in the market. Try to see what is being covered versus what we are covering here. So we have actually put a lot of effort to ensure we are covering almost all the critical aspects of a data protection officer, plus what is required for person to start from scratch to understand these concepts as well. So that's the reason module 1 and 2 is going to give you a lot of foundation, right? And module 1 especially is going to give you foundation about DPDP Act, right? And it will be given on comparison with GDPR in most of the topics, right? So in this way, you're going to see one, get the clear foundation of DPDP Act, plus on a comparison with GDPR, you know what are the elements which is extra in GDPR, and how to understand those concepts as well. So first chapter is all about your introduction and giving a complete coverage of fundamentals, and module 2 is about your data governance, right? So people who have ever attended my CAPM course, we can very well relate to this data governance as a foundation pillar of any data privacy program. So here we start with a roadmap, what needs to be done as a DPO in an organization if you're going to build a program from scratch. And we are going to look into some of the pillars of your data privacy program. It starts with your governance framework and then components of the framework, your privacy by design, data privacy policy, and notice. A lot of confusions exist with the terminologies that are there in data privacy. And what are the first of all, what is the difference between the policy and notice? What are the components of a policy? What are the components of a notice? And we are going to have understanding of different KPIs that is going to be that is going to be defined part of different components of a privacy program, right? And so another important element is we generally speak about privacy by design, right? But how we are going to strategize this, what are the data strategies, what are the process strategies, we're going to look into all of those things in much detail, right? So this course is going to definitely cover these elements, not just speaking at a high level. We will help you to understand what are the different strategies which you can implement at a data level as well as what you can implement at a process level, right? So these are some of the, and here in terms of governance, we are going to have case studies. Okay, case studies in terms of developing from scratch your privacy policies and notices, and we are going to guide you in terms of how do you create one for your organization from scratch, right? So that's going to be some of the interesting exercises which we are going to do. And after module 1, you will see case study and exercise is going to be a common element across all the chapters, all right? And module 3 is going to be data discovery, records of processing activity, and data retention, right? So data discovery is going to be one important disclaimer again. So some people may have a perception that we are going to use a tool, or it's going to be something which we are going to do with a tool on a hands-on approach. Actually, it's not the right approach, I would say, because this is something, a tool agnostic course. Today we might feel this is the best course and the best tool in the market, but tomorrow it's very easily going to be replaced. With the evolution of AI, there are so many tools which are coming in the market every 3 months. So you may never actually feel confident with just one tool, but rather understanding the logic and the process behind it is more than important for a DPO, right? Because see, understand, DPO is not a person who is going to run the tool as an admin, right? Imagine you're a data privacy manager. Your role is not to go and sit and do the data discovery with the tool, but rather you need to know about the capabilities of the tool, selecting the right tool in terms of whether the tool is fetching the right results, are your accuracy of the data which is being captured and mapped. These are some of the important aspects which we need to keep it in mind, right? So in that way, this course, we are not going to open any tool as of now, and there's going to be a tool agnostic course, right? But we will ensure that you will get every important nuances that you need to be aware as a DPO, right? And here we will try to show you how to build a ROPA, right, from scratch. And we will take use case, and then we will do a manual effort of how do we actually build each and every attribute of a records of processing activity, right? And we will also discuss in terms of how to define your retention period, how to dispose personal data, and we will see some related case studies to that. Okay. And next is your consent and cookies. So this is again a very important topic where many organizations are currently faltering. Even within the GDPR regime, many organizations have actually not done a proper element of compliance is your cookie consent, right? Many websites are still having those errors, and they have paid some hefty prices, penalties for that instead of price. Okay, so in this you need to now understand the crucial aspects of uh, providing a valid notice and then collecting a consent, and in terms of how do you build a cookie banner, components of a cookie banner, how do you do a cookie audit. So this particular module is going to go to a lot of depth to make you understand what are the different types of cookies, how to actually assess them, how do you build that, and how do you actually create it for an organization. All these things are going to be very it's going to be discussed at a lot of depth, right? So that's about your consent and cookie module. You will definitely be surprised to the depth of this particular module, whereas you would have not seen anywhere else in part of other courses. That's for sure. And these are the first 4 modules, and the remaining 4 modules are going to be equally interesting and important. The next is assessments. So the critical question that always comes is the comparison of the keywords that we find in different assessments, right? Your privacy impact assessment, data protection impact assessment versus your data privacy audit. So we are going to start with that important definition. What is the difference between them? And we are going to dig deep into DPIA because both GDPR and the Indian DPDP Act are focusing on DPIA terminology. We are going to look at the triggers, application, and how to compute the risk coming out of these assessments. We are going to look into a very detailed case study where we will be assessing the DPIA outcome, and we will be actually running a practical use case. Now, there are other assessments as well, which are legitimate use assessment. Both in GDPR as well as in Indian law, we have legitimate use. In GDPR, we have a specific assessment called as legitimate interest assessment. We call it as LIA. And in the Indian law, we have legitimate uses, right? So right now, we have around 9 legitimate uses which are outlined in the law. But very soon, if you see in the rules, you will have some specific requirement, right? So in that case, it's always a important practice for us to evaluate whether we are using the right legitimate use of a personal data. So that's something we will understand specifically from GDPR, and with that knowledge, we can very well apply for the Indian law as well. And the next is cross-border transfer and the transfer impact assessment. We call it as TIA. Again, a very important topic from GDPR. And right now in the Indian law, we have seen a very high level statement, which is like the government will issue notification for blacklisted countries, and except that, you can always send those data outside India, right? But we will definitely see rules which will come with some more specific requirements. Whereas in GDPR, we have a very comprehensive requirement in terms of transfer impact assessment. We are going to see a detailed understanding of those assessment as well. So again, in this chapter, we will have some interesting case studies plus a hands-on exercise, right? The next is your data subject rights management. Again, a crucial element in any data privacy laws around the world. So here we are going to understand the different data subject rights which have been outlined in GDPR as well as DPDPA. And we are going to see a detailed workflow. How do you actually complete a DSR response, right? A detailed workflow and process. And then we will look into the nuances of the derogations, which are critically, we call it as exemptions. And how do we actually look in terms of challenging situations. So these nuances which I'm going to share to you is generally when you start doing these responses over the years, then you get these insights. So we will give you all those insights in terms of how do you handle those critical decision points, right? And we'll again have a detailed case study there. And the next is your data breach management. And in data breach management, we are going to have some very important topics of incident versus breach, data breach definition in GDPR versus DPDP Act, and how do you do a data breach impact assessment? How do you notify the breach in terms of GDPR as well as DPDP Act, and data breach registers? So again, you will see at least minimum 10 different scenario and case study in this chapter. We will thoroughly see multiple use cases, and we will make this chapter something which you will remember for a very long time based on the different types of scenario which you will see, and you will be more confident in terms of taking the right decision, because it's a very critical part of a data privacy program. And as a data protection officer, you need to have that knowledge to take the right decision, because it's a question of your entire organization's reputation as well as your survival could be at stake, right? So that's why this chapter is very, very critical. And the last chapter is your vendor management. So vendor management, we are going to go into data processor due diligence. So this chapter is very critical from a DPDP Act perspective, because the Indian law has taken a stand in terms of not having specific obligation to the data processor, whereas in GDPR you will see some specific obligation to the data processor. And so that makes your selection of data processor even more critical in the Indian DPDP Act, right? So this chapter is going to be a very important cornerstone for all the Indian companies who are actually engaging with multiple third parties and vendors, right? So we need to do a very important assessment on all our existing third parties, because any flaw or any mistake that could happen at a processor end is going to be attributed to the controller, right? So that is the current version of the Indian DPDP Act requirement says, right? And also we are going to look in terms of what are the components of your data processing agreement and how to compile one. So these are the important elements of your vendor management. So if you look at all the 8 modules, you will see it almost covers every single element a data protection officer has to perform. There is actually not a single topic which has been left out, which will not be into the roles and responsibility of a DPO, right? All the most important elements are being specifically addressed, and we are going to have a case study and exercise for all these chapters specifically. Let's go for why this course and how this is different from other variants. Actually, this is not a comparison sheet between the IAPP courses, whereas I'm the trainer for all the first 3 courses. I do it on the weekends, and this course is going to be a weekday course between 8 to 10 p.m. IST. And how this course is actually different from any of the courses in the market, not just IAPP. We have CDPSE from ISACA, we have DSCA certifications. There are so many other variants that exist in the market, right? So if you see IAPP courses, they have a particular scope, right? If you take CIPP, which is Certified Information Privacy Professional, it has 4 variants covering 4 different laws around the world. One is GDPR, second is your US, third is Canada, and third is Asia, right? So this actually covers 4 different variants of regulations, and that gives you a legal understanding of how do you approach the requirements of different laws and how do you interpret that for your business, right? So this is a foundation course I usually say to any candidate who wants to start their data privacy journey. Start with CIPP-E, which gives you a very important foundation to understand a comprehensive requirements of a law, especially GDPR. Now, CIPM is a ideal course which targets about your DPO foundation, right? So DPO, if you are aspiring to become a data protection officer, a combination of CIPP and CAPM is generally recognized to become a DPO. Now, the challenge is that uh, if you are already working in data privacy, then this is the best combination that can help you. But what if in India, the course as well as the law has been very recently picked up, as the law itself is just 6 months, right? And the rules are not yet out, which means the market is very early stage, and you may not have that practical exposure of how do we implement this on a day-to-day life, right? So that's the gap which we are trying to fill with the DPO hands-on course, right? So IAPP definitely covers all your required elements, but expectation is that if you are doing it on a day-to-day working basis, then obviously you are already ready for a DPO. But if you do not have that practical exposure, then obviously there is a big gap that needs to be fulfilled, especially for the Indian market, right? So that's the reason we are coming up with this hands-on training, right? The third variant is your CIPT, which is privacy technologist. So how a technologist should approach data privacy and how to implement in your organization. So this is the different certifications. I can't comment about the other variants like CDPSC, about other DSCI courses, but each of them have a specific agenda and a specific objective, right? But IAPP courses are well recognized in the market. If you want to check, for instance, if you go to LinkedIn and try to find for a DPO role, right? Recently, SBI released openings for a DPO role, right? Data privacy manager. So you can see what certifications I mentioned. It's usually the IAPP courses, right? That's the reason I always go for certifications which have value in the market. Now, having said that, my candidates who have cleared the certification with my training will always come back to me, Jay, I have all the knowledge, but how do I apply? I'm not getting that opportunity to apply it, right? So that's where, to bridge that gap, we have come up with this particular variant of data protection officer hands-on training. All right. Now, who should join this course? Right? So people who are already assigned with DPO responsibility, or someone who's already assigned with as a authorized person for data privacy related requirements, or if you are a CISO for your current organization, most probably your CISO, as a CISO, you will be tasked with looking after your data privacy in your organization as well. This is the trend I've seen so far, because in my CIPM session, out of 20-25 people, half of them are CISOs from different organizations, right? So that's the trend which I've seen. Many of them are cross-skilling and upskilling themselves with the required knowledge, right? And also, whoever is planning towards shifting towards data protection, you might be currently in a data governance role, or you might be in GRC, or you might be in information security profile, or from the legal background. All of you are definitely apt for aiming towards DPO, right? So actually, DPO role is gonna have such a demand. Every organization, starting with medium to large scale, all of them will need. You may call them with different titles. You can call a DPO, data privacy manager. The titles are gonna vary, but the requirement for a single point of contact to govern the entire data privacy program for an organization is definitely going to there, because this is a legal requirement, and the penalty is going to be 250 crores in the DPDP Act, and the highest slab in GDPR is 20 million euros. And remember, this is for a single infringement, so you could even get a higher penalty, depends on what kind of the what count of penalty as well as the type of penalty that has occurred in your organization. So this can actually be higher. So having said that, organization are definitely going to take this seriously, and trust me, mark my words, maybe once the rules comes out, within, if they give 6 months, 1 year time period to comply, after that you will see at least 3 to 4 major announcements of data breach, not data breach, penalties will come up, all these targeting some of the big players in the market to send a clear message to the entire ecosystem, right? This is what happened in GDPR. The same will happen in India. Then every company will appoint someone to manage the data privacy program. So this is the best time for you to stay ahead of the curve, equip yourself with the required knowledge, and you can definitely be ahead of the competition, right? So that's why this course is going to be a very valuable asset for equipping yourself. So whoever are currently consultants or project managers, you can definitely go for this course, especially from Big Four or other consulting firms. Many of them have joined from my previous trainings. You can definitely opt for this. And individuals who are coming from background of audit, IT, legal, information security, data governance, all of these domains are very much apt for picking up the TPO role, right? And professionals who want to learn about DPDP Act for other reasons, maybe just for the knowledge, you are already leading your organization, or you are a founder of your organization. In all these ways, you can definitely equip yourself with the required information. One small prerequisite, it's not a showstopper. If you have a basic understanding and primary knowledge of both these laws, that's going to really help you in terms of picking up things much faster pace. That's the only prerequisite. All right. So why DPO with InfosecTrain, right? So that's again a very important question that needs to be addressed. So I, instead of reading out what is there on the left hand side, I'll focus on the key differentiators. So the key differentiators are that it's going to be a practical and quality preparation with sufficient time to understand complex topics. Certified instructor with FIP, that's myself, and my co-trainers are also going to be FIP, which with both CAPP and CAPM. Guaranteed low price. Trust me, this price is not gonna be the same after some time, and this is just the opening launch price, right? Because others give this same training for not less than 40,000 rupees. You can check anywhere in the market, and you will not find this course less than 40,000 or 50,000 in the market. I can guarantee you that. I've been in this training circuit for some time. I know the cost of this training, but this is going to be the pilot batch from my end. So that's the reason we are giving it at such a subsidized price. And it's going to be a complete case study approach with practical use cases. And there will be templates and other useful resources which will be included. And one of the important points which usually might candidates ask is recorded sessions. So this training will definitely you will have access to the recording, much to the relief of my previous candidates who find this as a challenge with IAPP trainings. But here you will definitely get recorded trainings, right? And you will get a wonderful collaborative group. There are a lot of people coming from wonderful background. Already have a community around me who I've helped to clear the certification. Also, a lot of people are in touch. So we are building a wonderful data privacy community around ourselves, and that's going to help all of us in terms of gaining this knowledge and working together, helping each other in this particular community. And you will get a certificate of completion and also some expert career guidance in terms of how to launch yourself into the DPO market. Just starting with few basic terminologies, right? And what is privacy, right? So someone who has not attended any of my previous sessions or webinars, I would say this is maybe the first interaction we are speaking with each other. So maybe I'll start with certain foundations so all of you can understand and appreciate this whole concept, right? So privacy is one of a concept where you do not have a standard definition. That itself is a significance of this particular concept. The reason is my privacy versus your privacy is going to be entirely different. I can give you a simple example, right? So I have certain practices of not sharing anything in social media or not posting anything in Instagram. I don't even have an Instagram account. Whereas someone in my family, they have a different perspective. They are happy to share a lot of things. So within my family itself, we have a difference when it comes to my perception of privacy versus another person's perception of privacy. And as a topic, it varies drastically from different regions as well, right? So that's the reason you will not find a definition. Like for example, if you have to define information security, you can always define it very straightforward with the confidentiality, integrity, and availability, correct? But when it comes to data privacy, there are multiple attempts. Starting from 1800, we had different versions of data privacy definitions, or they will give a perspective, right? So in general, if I have to give a high level statement, it's always a right to be left alone and not intruding in someone's personal and family life, right? Why we use the word right? Because the origination of privacy comes from your human right laws, right? It has an origin coming from your United Nation declaring two fundamental rights, which is right to be a right to private and family life and right to freedom of expression. So these two rights are the foundation of whatever privacy we are dealing with in today's form. And actually, when I say privacy, it's not just data privacy. There are other forms of privacy as well. We have territorial privacy, we have bodily privacy, we have communication privacy, and we have data privacy. So out of these four different forms, your data privacy is the most commonly affected element. That's the reason all these data privacy laws are more concerned about your data privacy, because it's been so easily accessed and most easily exploited as well, right? And we used to have this helplessness, right, against corporates and many organizations who are literally abusing our data in front of our eyes, but we never had the voice or the power to challenge them. So what is the data privacy laws around the world are now giving the power is to question these companies with the data subject rights, right? So ask the question, how did you get my data? What was a lawful basis to process this data? Delete the data if you are not doing it properly, and then making these companies bounded by a timeline to respond to this and take specific actions. If they don't, the penalty of that is going to be way higher, which is like 250 crores. 250 crores is like a make or break for many organizations. Trust me, big organizations, it's not just the number which is associated with the penalty, but the bigger damage could be a reputational loss, especially for a B2C, right? So they will have much bigger problem. Companies have disappeared because of these problems as well. Many of the companies, just because of data breach, that has disappeared out of the radar because they lost the trust of their customers, right? And we have data privacy as the core element of our entire course, as well as most of the data privacy law. And the DPDP Act is specifically focused on the digital personal data, right? So it is even more specifically scoped with the digital personal data, whereas GDPR also covers paper assets as well as digital data. When it comes to paper assets, we have certain specific qualification which can fit into the GDPR material scope, right? And data protection is a larger terminology which is usually accounted towards protecting your digital data, right? And this is little different compared to your data security, right? Because data protection is more of a data governance approach, right from your collection to your disposal. What are the specific technical and process controls which we build in the life cycle to protect the data, right? So that's the data protection approach. And whereas one stark difference between a data protection and data security is that in data security, we never worried about what data we collect in an organization, right? Our data security is always concerned about the moment the data comes into the organization. So how am I going to protect the data? How I'm going to ensure the value is going to be retained? How I'm going to ensure the data is accessible to the authorized people? So that is all about your information security, or we call it as your data security aspect of it. But whereas in data protection, in fact, we are going to go one level above this, and we are going to look into the collection aspect as well, right? And data privacy rightfully ask you those fundamental questions. Even if you have a permission to collect data from the data subject, are you collecting it appropriately, only relevant and adequate to fulfill the purpose for why you are collecting this data? So these aspects are so fundamental, and we need to know clearly the difference between these aspects, right? And when it comes to the governance, we have different terminologies, which is framework, and then we have a data personal data life cycle. Personal data life cycle typically starts from the stage of collection, and then we will go into the processing. The processing, in fact, even collection is coined as a processing. Part of the larger processing, we will be looking into using the data, storing the data, altering the data, modifying the data, or sharing this data. And all these transactions, what we do is all part of the processing. And finally, we will be either archiving or disposing the data as well, right? So all these aspects are critical in terms of ensuring the right controls, protecting the personal data across the life cycle. So this slide is one of my favorite slides to explain, right? What is the typical role of a DPO inside an organization, right? So if you wish to become a DPO, so you need to be aware about all these important aspects which I mentioned here, right? These are very critical elements so that you can actually very be thoroughly prepared to take up this very important challenge, right? So to aspire to become a DPO, what is the first and foremost step, right? Let's take a simple example. If I'm trying to apply for a DPO role for an organization, what's the first element which is going to be assessed from me is that how well I understand this organization. Or if you're already working in this organization, you have been assigned with a DPO role, right? So what's the first step? The first step is might be you are working for a role which is very simplistic in terms of the scope and coverage, but when it comes to data protection role, a data protection officer role, you have to have a very high level of visibility on your entire organization. So first and foremost step is understanding the business landscape and the operations on employee and customer personal data, right? So without this foundation step, you cannot do any further activities. That's the most common mistakes which many people do, is that they directly go into an operational approach, right? Operation approach is, I will jump into data subject rights, I will jump into your data breach. These are the critical elements. I'll just focus on that. But that always leads to a failure. If you do not understand your organization product and services, if you do not understand the threat landscape of your organization, you do not understand the culture of your organization, many a times you will not be able to fulfill your responsibility to the expected level. So that's the first important step. And the second is identifying your legal, regulatory, and contractual requirement of the organization. So whenever you're building your organization governance, right? So the critical aspect is knowing your compliance requirement. So your entire program has one core objective, is to fulfill legal and regulatory requirements, right? So if you falter on this, then your organization is going to pay a very hefty penalty for that, right? So understanding by the nature of the business, by the sector that you work in, right, it's not that easy like we think. Like, for example, let's take in India, we all think like DPDP Act by default is going to be the legal requirement, but that's not the only requirement. For instance, if you are working in banking sector, we also have the specific regulators coming in the picture. RBI has specific requirements when it comes to data protection, as well as they have some specific requirements on your information security as well as your data localization perspective as well, right? Similarly, we have multiple regulators, right? We have SEBI, we have TRI, we have other regulators who have some specific requirements, as well as for health data, we have sectoral requirements. For example, you might be having a US client, so you might be forced to have HIPAA compliance, right? You have PCI DSS as well. That also has element of personal data. Likewise, there are many sectoral laws, there are regulatory requirements, then there are legal requirements, right? So after beyond this, you might also have contractual obligation. For instance, if you are a processor, you are doing business across multiple entities in US or Europe, then you will also be bounded by multiple contractual obligation, right? As India being a IT savvy or a nation where we do a lot of IT backbone support for many of these vendors across US and UK as well as Europe, you will see many of the places we will play the role of a processor, right? So in that case, you will be mandated to fulfill GDPR obligation if you are working towards European counterparts, specifically to have processor specific requirements, which is outlined in GDPR, right? So now I hope you will be able to understand the importance of your understanding your legal, regulatory, and contractual obligations, right? Now, next is your gap assessment. So this gap assessment is typically outsourced to third parties, or it could be done in-house as well. So what is the reason of conducting this gap assessment? This gap assessment, for instance, any of the Indian company is trying to assess their as a status or current state assessment, to know what are the efforts required, what are the budget required, where do we stand in terms of our organization compliance, right? So it's a very high level assessment to showcase amount of effort required, budget required, the people, process, and technology requirements, right? Usually when I do this particular task as a consultant, we do a gap assessment against the specific law like DPDP Act, and then we try to carve out your strategy in terms of a roadmap for the next 3 to 5 years, and we come up with the other set of specific requirements like policy procedure to fulfill the gaps. So there are different approaches, but generally gap assessment is an important tool first to understand where do you stand in terms of these obligations, right? So once you do the gap assessment, immediately we try to do for your policies procedures, which essentially to be built towards catering to the requirements of the law, right? It could be fixing the gaps, at the same time building those capabilities as well, right? So generally people try to say this as exact sequence. I would don't say this as exact sequence, because your policies, procedures, and your data discovery should almost start on a similar standpoint, right? In fact, your data discovery can even start before. Immediately after your gap assessment, you might start with your data discovery, and the data discovery is essentially focused in terms of getting the visibility of your organization. Some of the matured organization would have already done a detailed data governance, where you would have classified the different organization data that they handle. Part of that, they will definitely flag what are the personal data that they do. So in that case, yes, you may directly start with your policies and procedures, but if you have not identified your personal data, that's going to be the biggest challenge. When should we start the DPDP Act compliance part, right? I would say right now. The reason for that is understanding what kind of personal data that we handle, what are the different channels we receive the data, to whom we share this data, right? If you do not have this visibility alone can take 3 to 6 months of minimum maturity, right? So if you need 6 months just to do this activity and mature yourself, then why are we waiting for the rules to come out? Because rules is not going to change what has been outlined in the law, and this data discovery is the bare minimum requirement along with the gap assessment for any data privacy law in the world, irrespective of wherever we are operating. These are the two primary activity we do irrespective of whatever the data privacy law is. One, understanding our current state. Second, starting your data discovery process. And trust me, when you do not have anything in your organization for data privacy program, if you're building from scratch, please do not go for a tool directly. You need to do this first to have some visibility of your organization. First understand, otherwise you will face challenges in terms of getting the return on investment from your tools, right? Your organization should have some capabilities inbuilt towards doing this. Discovery tools are excellent resource, but sometimes how do you ensure the tool results are accurate? With what confidence you will be able to assure that the tool is giving you the right results? For that, you need to have some visibility, right? So as a DPO, you need to be part of this entire data discovery exercise, where you know your organization. What are the different process? What are the different application accessing this personal data? What are the different channels where the data comes in? What are the vendors who are accessing our data? What are the sufficient guarantee measures that they have? All these things is part of your personal data inventory and records of processing activity, right? So without this, your organization is definitely going to face a lot of challenge, right? And part of your governance, you are going to define your policies, procedures, and you're going to have your roles and responsibility set up. You're going to have your privacy awareness workshop, which is going to be a critical element. Usually people push this training and awareness at the fag end, but I generally say that if you do not start your training and awareness at a very early stage, your organization is going to have a lot of cultural issues for people to understand what you're trying to do in an organization, right? If the people cannot appreciate what we are trying to do, then obviously they will not show enough interest, or they will not give the priority for the program what we are trying to implement, right? So your training should start at a very early stage parallelly. Start with your top management. The top management should send that message to the entire organization, and then it becomes a very important factor for each and every employee within the organization, right? So these are some of the initial important activities. And apart from that, you need to do your other implementations activity of controls, plus your ongoing assessments, including your DPIA, including your LIA, transfer impact assessment, vendor due diligence, vendor impact assessments. All these things are subsequent implementation activities which you need to do part of your regular assessments and control implementation. Apart from that, we have some crucial pieces of most of the data privacy law, which is your data subject rights, your data breach management, and international data transfer requirements. So these three pieces, I would say, as a critical element for any data privacy laws around the world. You will see this as a commonality of across all the data privacy laws that you can think of. And finally is your continuous improvement, where you define a KPI in your organization, right? And you will always try to sort of understand how do you improve over a period of time. All right. So this is about your Dattatre. From regulatory perspective like GDPR, can DPO also act as a CISO or perhaps silent CISO in an organization if declared as DPO from an organization? See, from GDPR perspective, it's very difficult call because the law actually leaves a lot of decision making to the stakeholders, right? So what the law says that any role that has elements of decision making when it comes to your purpose and means of processing, they cannot occupy the role of DPO. And that makes most of the roles within the organization not a fit for DPO parallel roles, right? That's the reason we usually see DPO is completely a separate hierarchy where they are positioned such a way they directly report to the top management, and they don't report to CISOs, legal, or any other intermediate stakeholders, right? So from the Indian law, you can still go ahead and do that, but from the GDPR, it's quite difficult to prove that the role doesn't have any sort of influence on the decision making. That's the challenge. And the important part about GDPR is that it gives you a lot of space for your decision making, right? The law is not prescriptive in nature. In fact, most of the laws in the world are not prescriptive in nature. But what they will do is, if you have taken a wrong decision, unfortunately, there was a bad day for you in terms of a data breach, then all of your decision is going to be questioned on that day. And this decision cannot go in your favor. The authorities will not accept that, especially in GDPR, right? So that's the reason our decision making has to be prompt, and we have to do it within what is being mentioned within the scope of the law. So this is your overall data governance. And in terms of personal data governance, we have a key element starting with your vision, mission, scope of your privacy program, developing an organizational privacy strategy, privacy framework and standards, and structuring the privacy team and governance model. So we are going to discuss all these elements part of your governance chapter in DPO course, right? So we will see the use cases of how to draft vision and mission, how to draft your scope, how to draft your privacy strategy, what are the elements of a privacy framework, what are the components of your privacy notice, components of a privacy policy, what is the difference between these two terminologies, right? And how do you structure a roles and responsibility and governance hierarchy within an organization? All these aspects will be discussed part of the DPO course, right? And this is one of common elements which you would have seen in terms of the IAPP curriculum as well. One is your governance models. There are three different layers. One is centralized, decentralized, and hybrid. So centralized is your top-down approach. Your decentralized is your bottom-up, and hybrid is a combination of both top-down and bottom-up. These models have their own advantages as well as disadvantages. Centralized model is very apt and useful for large organization with no lower delegation where any decision making is required, or specific requirements coming from different other customized requirement coming from the regions where they operate. For instance, if let's take in India, we have a large company, and it doesn't have any state specific privacy mandates, and basically they need to implement across India. We can go for a centralized model, right? But if you want to do the same model in US, you will struggle a lot because there are multiple state specific laws, right? In US, you do not have a one federal law that governs the entire data privacy in US. So there you might go for a decentralized model where the organization may have a high level policy, but most of the customization might happen according to the state where they are operating in, right? So that's an example of your decentralized, where the decision making is delegated to the people on ground or people who are at action. A hybrid is one of the very successful model where For example, as an organization, you're operating in multiple geographies, right? There will be a global data protection office which will be creating the best practices and your bare minimum requirements which is required for the organization protection. And then obviously you will cater to the different requirements of different data privacy laws, right? So the global office, data privacy office, will set up the core aspects, and then the privacy policies or specific requirements will vary from one jurisdiction to another jurisdiction. That's your hybrid model. So this is your operational life cycle and data life cycle in terms of what happens within the personal data. So if you see, the four core stages of any privacy program is assess your organization, discover your data, do those assessments, identify the gaps, and then identify the respective controls, implement those controls to protect the organizations, including building policies and procedures, sustain that activity with the in terms of the requirements of doing your in terms of conducting your training and awareness, as well as ensuring the program is continuously doing with privacy audits, or you're trying to assess them in terms of KPIs. And finally, the response phase in terms of specific responses which the organization do. It could be in terms of data breach and data subject. So this is one of the standard model which IAPP as well as many of the organizations follow. So this is one approach. And this is the second diagram, which is about your data lifecycle, personal data lifecycle, starting from create, store, use, share, archive, and destroy. So the approach of the DPO course is going to look at all these elements. How do we implement the respective controls into your data lifecycle approach, as well as your data governance approach of your assess, protect, and sustain and respond. So this is again one of the common topic which I usually discuss is your rationalization. How does one law will help in terms of catering to other data privacy laws, right? So the answer to the question is, majority of the data privacy laws around the world have 60 to 70% of core crux elements. It could be the principles or it could be the major requirements of the law, right? So that could be in the form of your data subject rights, in terms of having a privacy notice, right? In terms of securing the data, right? So these elements are almost common across most of the data privacy laws, right? So this is a concept, we call it as rationalization. So what is rationalization? Rationalization helps organization to find the most common elements across multiple data privacy laws that they need to cater, and then specifically look for the outliers. Another approach what we do is to look for the most stringent regulation, and when we comply with the most stringent version of the requirement, automatically we are going to be compliant with most of the other less stringent laws, right? Let's take an example. You are operating across the globe, you have multiple regulatory requirements. In that case, if you pick GDPR as your baseline requirement, then you're going to comply with most of the other data privacy laws because it's the most stringent one, right? That's one approach. And obviously, other data privacy laws in fact have certain specific nuances. For example, the Indian law has consent manager, which is quite unique in nature, only to the DPDP Act. For example, you have right to anonymization as a law, as a right in Brazil, right? And in Brazilian law, you have every company to appoint a TPO. It's a mandatory for every organization to appoint a TPO, right? And in the Californian law, we have right not to subject it to sale of the data. Likewise, there are certain specific nuances which could be very unique to some of the data privacy laws. Then the approach is to cover the commonalities across the different laws and then look for the specific outliers. So this is gonna reduce the duplication of effort when we are trying to cater to each and every law separately, right? So this is what we call it as a rationalization effort, part of our data governance. So this diagram is again, see, framework has multiple components starting with your different policies and procedures. So in our course, we will discuss the different policies and procedures and how they have a role to play in terms of data privacy program, and also what are the important elements of your governance. For example, you have your strategy, right? Part of the strategy, what we have design strategies. Your design strategies include your process as well as data, right? We also have people strategy in terms of how do you define your roles and responsibility into your organizations. This is all about your strategy, right? And also we also discussed in terms of your framework. So these components, right, are very critical to have a clarity, and in terms of what are the different components of a privacy program. All these elements, as I showed you in the course scope, all these things are very detailedly covered, right? So you don't need to worry about all these aspects, it's taken care in the course. So these are the components of, in general, about your privacy policy and privacy notice. One is what type of personal data that we collect, and why are we collecting this data, and do you regularly review the data for accuracy, and how do you store this, how long we keep this data, and can you comply readily with the individual's rights, which has been outlined in the law. So just an image for you to outline, but this is not something which is the actual content. In the actual content, we have much more details. For example, the components of a privacy notice versus a privacy policy. What is the difference between them, and what exactly you need to do as a DPO? We will be thoroughly discussing all these elements in detail. We'll move to ROPA. So this is some of the very common elements which needs to be covered part of your records of processing activity. And in fact, much more than that. Okay. So when we do our exercise, we will pick up one particular process and we will do a detailed walkthrough of all our subsequent processing activity. How do you fill all those components? Typically, when I do my consulting, my records of processing activity have 30 to 40 different columns. What you see here is only 4, but when I do it consulting, I ensure a very detailed records of processing activity is there. The reason is the law may only prescribe or suggest you to have bare minimum, but you just cannot run a company with bare minimum governance of what you have and what you do with your personal data, right? If you have a thorough ROPA, then as I told you, it's going to help you in many ways. At the same time, doing it right on the first attempt is also very important, right? You cannot go back again and again to the business to identify, to understand the entire life cycle of personal data. So do it much thoroughly when you start this whole exercise. All right. On the exact lines is the employee personal data lifecycle diagram, which I try to show you. As an employee, when we join an organization, even before joining, we share our CVs. There is an interview conducted. A lot of personal data is even collected at that particular point of time, right? So for this kind of data also, you clearly have a retention period. For example, CVs that are collected, if you are rejected by that company, they usually cannot have the data for more than 6 months to 1 year. The business purpose may be kept for 6 months, 1 year, saying that the candidate information is kept to ensure the candidate equip themselves better before reappearing for the same profile, right? So that's a valid business purpose. But beyond 1 year, there is no reason for keeping a rejected candidate CV, right? But just trust me, whoever is joining this webinar, you would have 100% seen all your organization have tons and tons of rejected CVs, right? That's a clear case of not having a lawful purpose to have this information. Tomorrow someone starts challenging you, why are you having this data, right? This is where you start your privacy discovery, right? You will immediately know, as a data protection officer or a data privacy manager, you know outright this is a flaw in front of your eyes, right? Likewise, there are a number of examples which we will discuss during our sessions, which will give you the insight of how to tackle or be aware about the possibilities, right? So likewise, all these different activities, from your recruiting, workplace, payroll, and also your personal assessment, as well as your exit, in all these stages, there are multiple personal data that is being collected and processed by the employee. One common mistake many organizations do is that they focus a lot on the customer data, but they fail to actually look after the employee data. But in my experience, I'll tell you, the most difficult data subject rights to fulfill usually doesn't come from your the data subjects like your customers, but it might come from your employees who are ex-employees basically, especially the ones who have left the organization on a disgruntled note. They are the ones who know a lot of inside information of the organization, right? So they will be able to make some of the most difficult data subject requests, and they will immediately file a complaint. So that's another point of view where you need to give equal emphasis to both your employees personal data protection as well as your customer personal data protection. Usually when I say personal data, it covers three important categories of people. One, your customers. Second is your employees. Third is your vendors. Even vendors' personal data also comes into your organization. So these three categories of personal data needs to be equally protected. It's not your customer data always proceed. Before the law, customer data, employee data, vendor data, it's all equal. There is nothing preference given in the law to treat customer personal data with more importance and leave out your employees personal data, right? This is something which usually organizations makes a lot of mistake, right? This is a data flow diagram just to showcase you how this is ROPA is converted into a flow diagram. Usually that is done to ease the process understanding. Someone who wants to do any quick action, they can usually refer to the DFD. It makes life much easier. Okay. So usually it's done across the different types of your stages, right from collection, storage, processing, access, transfer, and what are the different application accessing it, where do you store the data, and where do you share that information. So this is your data protection impact assessment, which is one of the favorite topic, what we call it under GDPR. Article 35 outlines what are the triggers for doing a DPIA and what are the steps followed in DPIA and in what stage you will be required to do one consultation. And we will see with lot of examples and use cases, and we will describe the difference between a DPIA and PIA and as well as the audit and how do we approach them. And we will pick up a very practical use case of running a DPIA to fill them up so that you will clearly understand how to do it in the future and you can confidently take it up. There's a transfer impact assessment. What are the steps involved in a transfer impact assessment? Again, whenever you are doing cross-border data transfer outside India or outside European Union, so what are the steps involved for you to ensure that you fulfill those obligations? This is a example coming out of GDPR. In the Indian law, we do not have such assessment, but it's always good to know a detailed assessment like TIA. It might very well come into effect in the future, right? So we will again understand this in a lot of detail in our session. So for international data transfer, again, we have some specific mandates coming out from the GDPR. So we will be discussing those mandates of what are the instruments to do an international data transfer. We have adequacy decision, we have appropriate safeguard, we have derogations. So all these aspects will be discussed in detail in terms of what are they, what are these instruments, how to utilize them, and how to actually engage for a third-party processor. How do you draft a data processing agreement? What are the components of a data processing agreement? All these things will be discussed in detail during the session. So again, vendor risk assessment. In terms of vendor, as I told you, vendor due diligence is going to be very, very critical in the Indian law, right? In the current version, you need to be absolutely sure in terms of hiring a data processor, because any flaw that happens at a processor or at a sub-processor end, it's going to be completely attributed to the data controller. So high time for us to go back and check the contracts, because as a controller, we are liable directly to the DPDP Act. There are no processor specific obligations outlined in the DPDPA. Most of them are going to be contractually passed to the processor and the sub-processor. So these nuances we will be discussing in detail, part of the vendor management chapter. Privacy by design, one of my favorite topics. A lot of people can speak at a high level, but what exactly goes into your design strategies is something which we will discuss during our sessions, right? So as I told you, this is the depth we will go into our design strategy, but there are different data strategies. Within the data strategy, what are the different methods? And also we have our process strategies. What are the different methods that we will be using there in the process strategies? And these are the different types of controls which we will be doing part of the technical and organizational measures, right? This is the DSAR. What are the different rights? What are the different elements to be looked at from the DSAR perspective? In this chapter, when we will look at the DSAR process flow. How do we respond to DSAR queries? How to structure our responses? All these things will be discussed in detail. Again, this is the DSAR workflow. These are very, very important. There are a lot of nuances in each of these steps. There are companies penalized exactly for making mistakes in one or the other components. For instance, verifying an identity of a user, right? In this case, if you make a flaw of asking extra information from a user which was not collected originally part of the processing activity, just in the sake of authentication, you may actually incur a fine. This is actually violating the data minimization principle. This has happened so many times in GDPR. There is n number of cases where they are flawed in terms of identification, right? So these nuances are very, very important in DSAR. And also in DSAR, you need to understand all the data subject rights are not absolute rights. Many of them may not be fulfilled because of certain exemptions which may exist. So these nuances, derogations, all these things has to be thoroughly understood. These are the components of your incident plan, and how do you craft your breach response as well as your breach impact assessment is one of the important chapter. So these diagrams are not coming into the course. I kept it for just illustration purposes.